All right, joining us this hour, criminal defense attorney, former prosecutor David Bruno, and former federal prosecutor Nima Rahmani. Gentlemen, thank you so much for joining me on the show. David, I'll begin with you, and we'll go back to the Daybell case. First and foremost, the prosecutor in that case, he filed a motion saying, look, we don't oppose them getting the minutes from the transcripts from the trial of Lori Vallow Daybell. Always a good choice to err on the side of judicial economy. No hearing in that instance. Great move, don't you think?
Yeah, it was a great move, and that's some good evidence. That's some good transcripts for the defense as well. Why does the defense want that? Because all of these witnesses that are going to be testifying in the next case probably already testified. And what the transcripts could be used as, they could use the transcripts to compare against their live testimony. Let's not forget, testimony comes from the stand. They can't bring the reports, they can't bring the transcripts, they can't bring all the other evidence up there. So if they make a mistake, if they testify differently from what they previously testified to, the defense will have those transcripts to mark, to use for identification, and cross-examine the witnesses to either attack their credibility or impeach them.
Thousands and thousands of pages, so let's not undercut the amount of work that that's going to require when they do get those transcripts. But Nima, you know, we've discussed this before, and I know you believe that this second trial is an advantage for prosecutors. But here's the question I have for you. This case against Chad Daybell is a death penalty case. Is there a greater burden, and I use that term loosely, on prosecutors when they're trying to go for the death penalty? Is it imperative that they bring in evidence that shows that he clearly was the ringleader? I think in Lori Vallow's case, it was clear that they were making it clear it was the two of them. Do they need to go a little further in the case against Chad Daybell?
I think so, Michael, and you're talking about the difference here between the guilt and penalty phase. I think you can convict someone for murder as an accomplice or a co-conspirator, even though you don't know who might have been responsible. We're seeing this a bit in the YNW Melly case, right, where a prosecutor can't really say, was it Henry, was it Melly, was it, you know, that killed the victims in that case. You know, here too, I mean, we don't know who killed JJ and Tylee. Was it Chad? Was it Lori? And I think that's going to make a huge difference during the penalty phase. Obviously, you know, during the guilt phase, I think we have plenty of evidence that they were both responsible. They both knew what was going on. But I think if you want to put someone to death, you really want those jurors to unanimously know who was responsible and who played maybe a lesser role as an accomplice or co-conspirator.
Absolutely, and I think it's going to affect the way they try that case. They have to make that clear for the jury if they get a conviction, then to go to the penalty phase and say, we want to put them to death. Let's turn now, David, to the YNW Melly case. It's clear in closing arguments and throughout the case that they suggest that the motive was greed, anger, and gangs. It can be suggested and has been suggested by the defense that that's not necessarily supported by the evidence. And I say to you, when you don't have strong motive and you have a case, which I think the prosecution does, and you can disagree with me, that requires a lot of inferences and innuendo and interpretations, as the defense said, by this jury, without that solid, strongly supported motive, I think that makes their case a little more difficult.
I agree, Michael. I agree, because like you said, this is a circumstantial case. It requires inferences off the evidence. And when we talk about inferences, there could be a number of different inferences. So the prosecutors are asking them essentially to look at all of these inferences one way. And while motive is not an element of any of the crimes charged, it's frequent. It's a frequent issue that juries discuss, and there's always that question, why? And I'll tell you, when the prosecutor comes out like they did today and they don't have a motive, they do not have, nobody knows what this motive is, and they start buckshot with all these different types of motives, and it could be this and it could be that, it starts to make people think in that jury room, especially on the circumstantial case, especially when the prosecutor's asking the jurors to find inferences. That could be a huge problem when it comes to proof beyond a reasonable doubt, the highest standard in our criminal courts.
Absolutely, and the defense took definite advantage of that in their closing arguments. All right, stand by, gentlemen. Coming up next.